Thanks everyone for being here today, and especially to our speaker for taking time out of his busy schedule to be with us. And thanks to all of you who are watching this recording later. Our speaker today is Benji Cover. He's an associate professor at the University of Idaho College of Law, where he teaches and writes about constitutional law and election law. His scholarship focuses on electoral districting, electoral reform, and democratic participation. He's been published or is forthcoming in the Stanford Law Review, the Iowa Law Review, the Harvard Law and Policy Review, the UC Davis Law Journal, the William and Mary Bill of Rights Journal, and Social Science Quarterly. He also authored the chapter on redistricting criteria in the forthcoming Oxford Handbook of American Election Law. If you have questions throughout the presentation, feel free to put them in the chat, and then we'll have some time at the end for Q&A. So without further ado, I'll turn it over to Benji for his presentation today on Idaho initiatives.
Thanks very much for that kind introduction, and thanks for inviting me to speak with you all today. I've been talking to a lot of people after last week's election results. I've talked to some people who are very upset about those results. I've talked to people who are very happy about those results. As somebody who teaches and writes about election law, it's a reaffirmation for me that elections matter. That voting matters, that candidates matter, that campaigns matter, and that election rules matter. For today, I've been asked to talk about the initiative process in Idaho. And so I'm gonna run through a brief presentation, just kind of outlining what the Idaho initiative process looks like. But I'll try to leave a bunch of time at the end for Q&A and kind of open it up so that I can address whatever attendees are interested in chatting about. Does that sound good? Okay, so let's dive in. So in Idaho, we have the constitutional right to the initiative. Article 3, Section 1 of the Idaho Constitution says the people reserve to themselves the power to propose laws. And to enact the same at polls independent of the legislature. And I think one interesting question for me as an election law scholar is, why would there be a law that the Idaho legislature itself would not pass, but that the people would pass independent of the legislature? Under some theories of representation, you might think that if most people want a law to be passed, then they'll elect leaders who pass that law. But it turns out it's not that simple. And we've had some recent examples here in Idaho, perhaps most notably with Medicaid expansion, right? Session after session, the Idaho legislature refused to expand Medicaid. But then when the question was put to people as a ballot initiative, it passed. So this power is known as the initiative. Note that there's referendum and there's initiative. Referendum is the power to repeal a law that the legislature has passed. The initiative is the affirmative power to enact new law that's not been adopted by the legislature. And this provision of the Idaho Constitution goes on to say that legal voters may initiate any desired legislation and cause the same to be submitted to the vote of the people at a general election for their approval or rejection. But notably, it says that legal voters may do this under such conditions and in such manner as may be provided by acts of the legislature, right? So we have this constitutional right to initiative, to engage in direct lawmaking that's not mediated by the legislature, but the legislature does have a role in deciding how the initiative process works. And so if you want to understand how the initiative process works, the first place to look is the Idaho Code. Title 34 governs elections. Chapter 18 governs initiative and referendum elections. And throughout the presentation, I'll try to cite to the statutory provisions that are relevant. The Idaho Secretary of State on his website has a good description of the requirements for filing an initiative. So that's a good source as well. There's also Ballotpedia does a good job of summarizing Idaho's initiative laws. Sorry, I'm just going to check. I see that I am getting some chats. Should I try to um,
I think we can just address them at the after the
should I hold
presentation.
off till the
Yeah.
Q&A? Okay.
Yeah.
Okay. Yeah, so feel free to add any questions as they occur to you in real time in the chat, and then I'll look at them in the Q&A. Okay. Okay. So um, here's a list of players in the Idaho initiative process. You've got the Secretary of State, who I'll sometimes refer to as SOS, and then you've got the Attorney General, who I'll refer to as AG. This is an interesting aspect of the initiative process in Idaho because the Attorney General is elected as the state's top lawyer. The Secretary of State is separately elected as the state's top election officer. And they each have distinct roles to play in the initiative process. You also have the Division of Financial Management, which does the fiscal impact statement for proposed initiatives. You have the Idaho Supreme Court, which has played a really important role in regulating the initiative process, especially in the last decade or so. You have the person or organization, or people or organizations that are actually sponsoring the initiative. They're sometimes referred to as the initiative sponsor. They're sometimes referred to as the petitioner because they're the ones who are filing the petition for the initiative. I might sometimes refer to them as SP for sponsor or sponsor petitioner. You've got qualified electors, uh, and then you've got paid signature gatherers. Okay, and then uh, we can divide up the initiative process into 6 steps. Step 1, there is this pre-review filing by the sponsor. I'm going to lay out these 6 steps, and then I'll go through each one in turn. Um, then you have a review process that involves the Attorney General. Um, After that, you have a post-review filing. You then have ballot title assignment. And then you have the preparation and circulation. This is when you're trying to get lots of people around the state to sign on to the petition, get enough signatures to get it on the ballot. And if you're successful, then you actually get an initiative on the ballot and Idaho votes on the initiative. I'm going to focus on the first 5 steps, but I'm happy to discuss step 6 as well during the Q&A. Okay, so let's start with step 1. If you want to get an initiative on the ballot, you as the sponsor must file with the Secretary of State 2 things. One is the original initiative proposal. And Idaho law tells you what this should look like. You're basically saying, hey, Secretary of State, I hereby declare that I would like to propose that we change Idaho law in the following way. And then you explain the statutory change that you're looking for. You need to include with that information about funding source. So you need to ask yourself the question, is this going to cost money? And if so, how are we going to pay for that? And you need to submit that information along with the initiative proposal itself. There are some procedural requirements at this stage. When you file this initial proposal, before it's in the pre-review process, you need the signatures of 20 qualified electors. And when I say qualified elector, it's a synonym for legal voter, right? So we're thinking about somebody who meets the requirements for age, citizenship, residency, and somebody who has not lost their voting rights due to a disqualifying felony conviction. the statute's really specific about the procedural requirements. So, for example, if those 20 voters who signed when you do the initial pre-review filing, if they're from different counties, you need to have a separate signature sheet for each county. Okay, so you make sure that you've crossed your I's and dotted your T's, and you submit a procedurally compliant pre-review filing with the Secretary of State. The Secretary of State's going to immediately transmit that to that finance department and to the Attorney General. And then they're going to begin their review process, right? So the Division of Finance and Management, um, they've got to submit to the Secretary of State a fiscal impact statement, right? So they're looking at your proposal and they're saying, here's how we think that this would affect the budget. Here's how much we think it would cost. They have 20 working days with it from the receipt of the petition to submit that fiscal impact statement to the Secretary of State. While DFM is looking at the fiscal impact, the Attorney General is thinking more broadly about the proposed initiative. So the Attorney General reviews the proposal, and they can suggest edits to the sponsor. They could say, I think this might be unconstitutional and you need to change it in this way. Or they could say, I think this isn't going to work practically and you need to change this part or you need to explain this part. So the Attorney General can make substantive edits and submit those substantive edits to the sponsor. These substantive edits are not binding. They're purely advisory. And the statute is clear that the sponsor can accept them or reject them in whole or in part. But the Attorney General has to do that review process and has to communicate to the sponsor any suggested edits within 20 days of receipt of the petition from the Secretary of State. During this process, the Attorney General may just meet with the sponsor or consult with the sponsor and ask questions, explain what the Attorney General's concerns are. There could be a back and forth between the Attorney General and the sponsor at this stage. But within that 20-day period, the Attorney General has to communicate any suggested edits. And then whether the sponsor is going to accept them or not, the Attorney General has to file a public document with the Secretary of State that is called the Certificate of Review. The purpose of this document is to publicly declare, hey, I, the Attorney General, did what I was supposed to do. I reviewed this. And here are the suggested edits that I made, and I communicated those suggested edits to the sponsor. That's a public document that people can see. Once the Attorney General has filed that certificate of review with the Secretary of State, that starts the clock back on the sponsor. The sponsor needs to decide, are we going to go ahead with this or not? And are we going to accept any of the suggested changes from the Secretary of State or not? So after that review, the sponsor needs to file with the Secretary of State a final initiative proposal, which with any edits the sponsor might elect to make based on the suggestions from the Attorney General. And that could be accepting everything the Attorney General says, accepting nothing from what the Attorney General says, or accepting some of what the Attorney General says. In any case, the sponsor has to submit to the Secretary of State their final initiative proposal within 15 days of when the Attorney General issues that certificate of review. Once that happens, the Secretary of State sends the final initiative proposal to the Attorney General. This is what triggers step 4, which is assigning ballot titles. It sounds like kind of a boring technical thing to decide the titles of the ballots, but it could actually be really crucial. It could be really controversial. It could be the subject of important Idaho Supreme Court case law. And it actually has been most recently with the Open Primaries Initiative. So what the Attorney General is supposed to do is they look at the final initiative proposal from the sponsor, and they need to send to the Secretary of State both a short ballot title and a general ballot title. So the short ballot title has to be less than 20 words, the general ballot title less than 200 words. The Attorney General is supposed to do this within 10 days of receiving the final petition. But if the sponsor doesn't like these ballot titles, actually, if anybody doesn't like these ballot titles, any dissatisfied person can appeal these titles to the Idaho Supreme Court within 20 days after the Attorney General files those titles. Note that most lawsuits start in a district court and then they get appealed to an intermediate appellate court, and then they might ultimately go up to the state Supreme Court. Not here. This is a direct appeal to the Idaho Supreme Court. So it's kind of an unusual legal procedure. And then the Idaho Supreme Court needs to certify to the Secretary of State the final ballot titles. After hearing argument from both the Attorney General who proposed them and whoever it is that's dissatisfied with them. The statute says that when the Attorney General is writing these ballot titles, the Attorney General shall, to the best of his ability, give a true and impartial statement of the purpose of the measure, in such language that the ballot title shall not be intentionally an argument or likely to create prejudice either for or against the measure. All right, so the statute has the substantive standard for ballot titles. The ballot titles are supposed to be accurate and descriptive. They're not supposed to be pejorative. They're not supposed to be prejudicial. This came up with the most recent ballot initiative to reform the primary and general election process in Idaho, right? So last year we got this case called Idahoans for Open Primaries. As I'm sure you're all familiar, we used to have an open party primary in Idaho, right? So before 2011, when the Republican Party was choosing its party's nominees for state offices, you didn't have to be a Republican to participate in the Republican primary. But the Idaho Republican Party challenged that, and they won. So in 2011, federal court said that the Republican Party has a First Amendment right to control its own nomination process. And so if the Republican Party wants to, if the Idaho Republican Party wants to, it's allowed to close its party's primary and restrict it to only Republicans. And that's exactly what the Idaho Republican Party did. And so since 2011, the Idaho Republican Party has had a closed party primary where Republicans are choosing the nominees for the general election. And as everyone on this call knows, for a lot of races in a lot of places in Idaho, that's where the real action is, because whichever Republican wins that primary, they're going to go on and win the general election. And so that's shutting out a lot of people from what in a lot of circumstances is the most important decision point in the electoral process, right? So Idahoans for Open Primaries wanted to reform that process. They wanted to replace it with a primary that was nonpartisan, that would be open to everybody, and that would select the top 4 candidates to move on to the general election. And then people could express their preferences for the top 4 candidates using ranked choice voting. And that would determine the winner of the office of the general election. So I just used a lot of words to describe this proposal, right? The ballot title has to express this in less than 20 words. The short ballot title less than 20, the general ballot title less than 200. What's the accurate, non-prejudicial non-argumentative way to describe this, right? The Attorney General proposed, let's call this a non-party blanket primary. The sponsor said, nobody knows what that means. That's going to confuse everybody. That's not accurate and it's prejudicial. Let's call it an open primary. And the Attorney General said, well, that's confusing too, because what we used to have was an open primary, but it was an open partisan primary. What you're proposing is an open non-partisan primary. And so we need to use different language to make clear to people that we're not just going back to the way it was before 2011. The Idaho Supreme Court agreed that the Attorney General's description is inaccurate. They also agreed that the sponsor's proposed ballot title was inaccurate as well. And they said, what we need to call this is a top four primary. And so this was a really interesting decision where you had the Idaho Supreme Court really getting into the minutia of what's the right language to, in an accurate, descriptive, non-prejudicial way, communicate to the voters of Idaho what exactly this proposal is suggesting. Okay. Once you've got your ballot titles finalized, the Secretary of State submits to the sponsor three things. Here are the finalized ballot titles, short and general. Here's the fiscal impact statement. And here's the approved form of the initiative. Once the Secretary of State has issued that, the sponsor can use those materials to go gather signatures. They start circulating this initiative proposal and they try to get enough support from Idaho voters to get it on the ballot, right? So this is the point where the initiative sponsor is trying to get the initiative on the ballot by getting enough signatures. That starts the circulation period, and the sponsor has to gather sufficient signatures during the circulation period. The circulation period is 18 months from when the sponsor receives these three items from the Secretary of State, or April 30th of the election year for when the initiative's supposed to be voted on. Whichever one comes first, right? So through all these slides, I've been telling you what the timing requirements are. I've said now this person has 10 working days to submit this. Now this person has 20 working days to do this, because you need to get through steps 1 through 5 fast enough that you're going to leave the sponsor enough time to actually gather signatures, right? So if you're a serious sponsor that's really trying to get an initiative on the ballot, you need to work backwards, right? And you want as much time as possible to get signatures. And so you want the full 18-month circulation period. So you need to think, when do I want to get this on the ballot? If you want to get it on the ballot in 2026, you need to look at April 30th of 2026, work backwards 18 months and ask yourself the question, can we get through steps 1 through 5 fast enough so that we get the full 18-month circulation period? Because in that 18-month circulation period, the sponsor has to get a lot of signatures, right? How many signatures? Well, it depends on how many voters you had at the last general election. You need to get at least 6% of the qualified electors at the last general election in each of at least 18 of Idaho's 35 legislative districts, right? So the state of Idaho is divided into 35 legislative districts. Each legislative district elects 1 senator and 2 representatives. Because of the requirements of 1 person, 1 vote, each legislative district has roughly the same population. And you need to get at least 6% of the qualified electors at the last general election in each of at least 18 of Idaho's 35 districts. So that's a majority, right? The legislature tried to change this 18 number to 35. instead of a majority of the districts, the Idaho legislature said you need to actually get 6% of the signatures in all of the districts, right? They did that after Reclaim Idaho was successful with Medicaid expansion. Reclaim Idaho then sued and said that requirement is so burdensome that it's actually violating the state constitutional right of Idahoans to the initiative process. And the Idaho Supreme Court agreed and struck down that statute, saying that it violated Article 3, Section 1 of the Idaho Constitution. That's the language I read at the beginning of the presentation, saying that the people of Idaho reserve to themselves the power of initiative to independently change the law without going through the legislature. Okay, so it's 18, not 35. But that's still a lot of legislative districts, and 6% of voters in each one of those is a lot of people. So it's a lot of signatures. But if you can do it, if you can get all those signatures, then you get on the ballot. I want to get to Q&A, so I'm not going to get into all the details here, but I just want to note that there's lots of other rules about the circulation process and about how you get signatures. There are rules about who can provide signatures, right? Who's eligible to provide a signature, and what information do you need to give people who are going to provide a signature, and what information do signature providers have to give when they sign. There's also requirements about paid signature gatherers, including there's some new requirements that we just got this past legislative session. So paid signature gatherers might have to disclose in specific ways that they are a paid signature gatherer. And so there's rules about who's eligible to be a paid signature gatherer, and there's rules about what information they have to disclose and how they disclose that information when they try to get signatures. And then there's a detailed process where signatures are verified. Every single signature has to be verified, right? So I talked before about you need to get a lot of signatures. You probably need to get even more signatures because not every single signature is going to be verified. A signature might be thrown out because it doesn't have the correct information, because the person's not eligible, etc. Right? So usually people don't have a 100% verification rate for their signatures. You know, if you have a verification rate in the 90s, you're doing really well, right? So for that reason, you need to have a buffer. You need to not just get the requisite number of signatures, you need to get more than that so that the number that are actually verified gets you over the top. If you can do that, then that doesn't mean you get to pass the initiative. It just means you actually get to put the initiative on the ballot. And so, we just saw this last week with the top 4 primary initiatives. The sponsors got through all of that. They fought through every step of the way, and they won every step of the way. A lot of volunteers worked really, really hard and got all the signatures they needed. They got the signatures verified. There were lots of efforts to try to prevent that initiative proposal from getting on the ballot. Those efforts were unsuccessful. The initiative got on the ballot, but it was rejected by the people of Idaho, right? Now, you can try again in the future, but everything I've described is just getting it on the ballot. The final and most important thing is you need to persuade your neighbors to vote for it, right? And you need to persuade enough people to vote for it that it actually passes. So I'll leave it there and open it up for questions. And should I start by just looking in the chat?
Sure, I can actually read the ones in the chat so you don't have to skim through them. So from Joe, he had a question about the election that just happened. He said, when I voted, I had to fill out my ballot twice. The first time I voted yes for the first initiative, thinking Proposition 1 would be the first initiative. Then I read it more closely. and realized I voted yes for the wrong initiative, so I had the ballot voided. He's wondering if this is common, if there could have been mistaken votes, and maybe another way to say that is, might Proposition 1 be on reflection a bad ballot title since it might appear as the second initiative? Does this cause confusion?
Yeah, that's an interesting question. In any given year, there might be more than one referendum or initiative or legislatively proposed constitutional amendment that the voters are asked to vote on, right? So this past election cycle, the people of Idaho were asked to vote on two things, right? One was the Idaho legislature proposed an amendment to the Idaho Constitution, um, kind of explicitly providing with an exclamation point that um, that only citizens can vote in Idaho, and that non-citizen voting is prohibited at the state and local level. Um, that you know, Citizens can propose statutory changes through initiatives, but only the legislature can propose constitutional amendments. So that was one thing on the ballot. The second thing on the ballot uh, was the proposed initiative to reform the primary and general election process. Um, and I'd have to go and check in terms of the order that it appeared on the ballot, if they always will first put a proposed constitutional amendment before they put proposals for statutory changes like a citizen initiative, right? Um, don't quote me on that. I'm not sure if that's the required sequencing. I want to go double check if that is the required sequencing, and I could get back to you on that. But one thing that I would say is that it's true that in any given election cycle, there could be more than one, uh, there could be more than one question that is put to the people, right? Um, you know, in Idaho, we're actually lucky. We usually only get one or a few, right? In California or Arizona, you can get, several dozen questions that are being put to people. And so you can get a really long ballot and it could get really complicated. And actually, there can be some kind of strategic things that people do, right? So, for example, if some people want to put an initiative on the ballot to provide abortion access, right? People who are opposed to that initiative might try to get their own second initiative on the ballot that would restrict abortion access, right? And that might be really confusing for people because it might be vote yes on three, vote no on five, right? Um, so it does mean that voters have to be informed about what's on the ballot, what sequence it is, and what a yes vote means, what a no vote means. Um, and ideally, look at the ballot in advance and decide in advance, do I want to vote yes on one? Do I want to vote no on two? Right? Um, One thing that I think Idaho state and local election officials do a really good job with is that they make it easy for Idaho voters to view their ballot in advance, right? So I think the Idaho Secretary of State has done a good job with this, where you can go to Idaho Votes, and you can put in information to see so that they know, where in the state you are. And then you can click on View Sample Ballot. And so before the election, you can just go and look at that ballot and you can make sure that you know what's on the ballot. And uh, if there's any initiative or referendum or proposed constitutional amendment, you can check in advance how many they are, what the sequence is, and what a yes vote means and what a no vote means, right? Um, there's a question, do I think that the results last week were a product of confusion? Um, I doubt that it was a deal breaker. I don't think that the initiative would have passed, but for people being confused about what with the sequencing, or what yes meant or what no meant. Um, I do think it's possible that in a more general sense, though, um, it it failed because of a lack of voter education, in the sense that a lot of people in Idaho aren't familiar with this proposed electoral reform. A lot of people aren't as comfortable with ranked choice voting, and they're concerned that it might be confusing, right? And so, in that sense, I think that um, the proposal that failed this last week might be more successful in the future if there's more work invested into educating voters about it.
We have a few questions from Francis. I'll just start with the first one. Can only lawyers propose an initiative?
So there's no formal requirement that you have to be a lawyer to propose an initiative. To propose an initiative, you just need signatures from 20 voters for that very first step, and then you need to start going through all the steps. But as a practical matter, the process of um, getting an initiative through all the steps that I described and actually getting it on the ballot can be complicated. And so it could be helpful to have somebody with legal training that's kind of working through that process, right? And so I think practically, most successful initiatives are often brought by organizations that have access to lawyers with experience and training in this, but there's no formal requirement that you have to be a lawyer. And if you have a non-lawyer who's just really committed and very detail oriented, as long as they check every box on the checklist, they could lead a successful initiative in Idaho.
And going along with that, how do they decide an appropriate funding source? Or maybe like what are some examples of the funding sources?
Yeah, so it depends a lot on the substance of the proposal. If there's an initiative proposal that's, for example, trying to change the way we fund education, saying we want to increase funding for education, and here's how we're going to pay for it, then you need to do some math, and you need to say either we're going to cut funding somewhere else, or we're going to increase revenue in certain ways. And so if somebody's interested in um, an initiative that is budgetary or fiscal in some sense, I would encourage people to look at there was an initiative proposed about education funding, and you could look at what that funding statement looked like. Um, but other initiatives might have very limited fiscal effects, or might have no fiscal effects, right? Um, in which case the fiscal impact statement might say this is not expected to have a significant effect on either revenue, uh, you know, input, money coming in or money going out.
And I think you talked about this a little bit already, but maybe we could use this to talk about any upcoming initiatives too. So Francis asked, how common are initiatives? So obviously, some states have a lot. Of course, some states don't have this at all. So in Idaho, how frequently do we see these? And, are there any that we can look out for in the next couple of years?
Yeah, so I think that, about half of the states in the country have an initiative process. Of the states that have an initiative process, um, you can ask the question, of those 25, 24 states, how easy or hard is it to get an initiative on the ballot, right? Um, I, some of the I told you some of the features of Idaho's process, right? I told you that you have 18 months to get, 6% in 18 out of 35 districts, right? Um, it would be a lot harder if instead of being 6%, it was 10%, right? And instead of being 18 months, it was 8 months. And instead of being 18 out of 35, it was 22 out of 35, right? And so if you look at the states that have initiatives, there's all these kind of dials that you could turn to make it easier or harder, right? And basically, what happened in the Denny case that I discussed is the Idaho legislature tried to take one of those dials and crank it up so much that the Idaho Supreme Court thought they had gone too far, and they weren't just regulating the initiative; they were kind of eviscerating the initiative. Um, but uh, but the fundamental point is that amongst the states that have the initiative, there's significant variation in how easy or hard it is, right? And I think that's one of the key determinants of how many initiatives get on the ballot. Um, I think the other determinant of how many initiatives get on the ballot might have to do with how populous the state is, right? And so in California, there's a lot of people who might be trying to use the initiative process. So I would say that relative to other states, the frequency of the initiative process in Idaho is moderate. I'd say Idaho has a moderate number of initiatives each election cycle, and that states like California and Arizona often have significantly more going on than Idaho does. And then
Karen, oh, go ahead.
what was the other part about future initiatives?
Just if there of any efforts for initiatives that folks are trying to get on the ballot in the next couple of years.
Yeah, obviously, one of the biggest issues for initiatives nationwide in the last few years has been abortion. Um, and so in the few years after the U.S. Supreme Court overturned Roe versus Wade, there were some really important state initiatives where abortion access was codified in state law through the initiative process. And it was notable partly because initiatives were successful in places that people might not expect, states like Kansas or Kentucky, where people might not think of it as a blue state, where traditionally you would get support for an initiative like that. But there has been significant success. Uh, Last week, nationwide, I think 10 different states had some initiative related to abortion, um, some going in different directions. So I'd say in Idaho, as well as in other states going forward, abortion is one issue that might be the subject of an initiative, but I can imagine other ones as well.
Thanks. And Karen asks if a proposition is successful, are there any restrictions on the legislature overturning those results?
Yeah, so that is an excellent question. So this just happened in Utah, which is important because Utah's state constitution is similar to Idaho's state constitution. And they're in some ways, uh, the Idaho state constitution may have used similar language with a similar purpose to the Idaho state constitution, to the Utah state constitution. And the Utah state constitution codifies a right to initiative, kind of like the language I shared on the very first slide. But it also says that people retain the right to reform their government. And the Idaho Constitution has similar language. So um, there's an initiative right, but there's also a right to reform, which is similar to language that's in the Declaration of Independence that says, in the course of human affairs, when your government's not serving when the government's not serving the interests of the people, it's the right of the people to reform that government, right? There's language about that in both the Utah and the Idaho state constitutions. The people of Utah passed an initiative to try to reform the process of electoral districting. So they were worried about gerrymandering in the state. And they said, and the people of Utah passed an initiative that said there should be an independent commission that draws the maps. Um, and it provided details about what that looks like procedurally and substantively, and it passed. And then the Idaho legislature said, okay, well, you want to have you want to have a commission draw the maps? That's fine. We'll set up the commission, they'll draw the maps, but those maps are just going to be advisory. They're not actually going to be binding. And then we're going to let the legislature really make the final decisions about how to draw the maps, right? Um, the sponsors of that initiative filed a lawsuit against the legislature and went up to the Utah Supreme Court. And the argument that the sponsors made is um, if the legislature is allowed to do this, if they're allowed to change the initiative so much, then they're violating our right to initiative and they're violating our right to reform our government in the way that we want to reform it. And the Utah Supreme Court agreed. Um, so in the world of initiatives, that's a really important decision. And it's a decision that might have significance in Idaho because Idaho has very similar language in its state constitution. Um, so, if there's an initiative in Idaho that's successful in the future, and the legislature does something that really undermines the initiative, that's, really trying to eviscerate the initiative completely, then especially if it's an initiative that deals with kind of the way that the Idaho government operates itself, there might be an argument made to the Idaho Supreme Court that the legislature has gone too far. We've seen that the Idaho Supreme Court has been sympathetic to the argument that the legislature has gone too far when they regulate the procedures of the initiative, like saying you need to go to all 35 legislative districts, not just 18. This would be saying that the legislature has gone too far on the substance of trying to uh, take away a successful initiative. And so I think that there's a possibility out there. Um, it would require some sort of line drawing exercise by the Idaho Supreme Court. Um, you know, I don't think that any little change that the legislature makes is going to be considered unconstitutional. And I think sometimes you need the legislature to pass some laws that help to implement the initiative, right? Um, but I think there might be a good argument that the legislature can go too far, where they're not trying to help implement an initiative, they're trying to basically backdoor kill an initiative. And I think it's possible that there might be a limit on how far the legislature can go there. That will be the subject of a future decision by the Idaho Supreme Court. Other questions?
So Connie's put in a lot of helpful information on the difference between constitutional amendments and initiatives, and also some information based on her experience as a poll worker. So if people want to check out that, that's in the chat. And then I just want to note Lee Hendricks also said the AARP unit in Pocatello invited LWVP to explain Proposition 1. What I saw was that the layered approach to voting and follow-up in case of a tie was the most confusing to the members. So members wondered if their vote could be misconstrued and were thus against Proposition 1. So maybe if the proposition had only been about opening the Republican primary, it might have passed, in my opinion. So I guess, Benji, my question for you with that is the initiative couldn't have been just about opening the Republican primary, though, based on that Supreme Court case. Is that correct?
Um, yeah, that's a really good question. Can I just address one thing before I
Yes.
get to that question? Connie made a really important point in the chat that when it comes to candidates, the order of the candidates' names on the ballot is randomized. That's exactly right. I don't know if that's true with initiatives and referenda and constitutional amendments. That's what I want to check. Um, but the reason why it's randomized is so you don't get one candidate that gets some sort of structural advantage because they always appear first, and everybody and people tend to check the box for the first one when they're not sure who to vote for. Um, and so you might be worried about a similar effect with non-candidate questions. Okay, but going back to the um, the unsuccessful effort to the the failed open primaries initiative. So yeah, the initiative had two parts to it. It tried to change the primary process and it tried to change the general election process. And the idea was to change the primary process by um, letting everybody participate in a nonpartisan primary, where everybody chooses who they want and the top four candidates move on to the general. That's fundamentally changing the purpose of the primary. Instead of the primary being about choosing a particular party's nominee, the purpose of the primary would now be just trying to winnow the field to the strongest candidates. But it would have nothing to do with choosing the nominee of any particular party. And in fact, you could get multiple candidates from the same party. And actually, that's what you would expect in a place like Idaho. You'd expect that you wouldn't just have one Republican amongst the top four. In a lot of cases, you'd have two or three of the top four would be Republican candidates, right? So it's not about, it would, it would not be about choosing a party's nominee. It would be about trying to get the strongest candidates before the general electorate. But then the second part of the proposal answers the question, well, what do you do with the general electorate with these four candidates? And the idea is you let people rank them, and then you use the process of ranked choice voting to select the candidate. Theoretically, you could have the first part without the second part. But if you had the first part without the second part, um, then we'd have four candidates, and people would not be able to rank those candidates, and they would just vote for their favorite candidate. And the baseline rule, if we don't change it, is the plurality rule. And the plurality rule is whoever gets the most votes wins. But I want to be really specific about what I mean when I say whoever gets the most votes wins. I mean the one candidate who gets more support than any other individual candidate wins, even if they get significantly less than 50% of the vote, right? And so what that means is if you have four candidates running, um, one of them gets 28% of the vote, and the other three get 24% of the vote. Under the plurality rule that we use today, the candidate that with 28% of the vote wins, even though 72% of voters voted against them. That's the problem with having a top four primary, but not changing the general election system. You can elect candidates with who have a plurality of support, but not a majority of support. And you could end up winning an election with just like 30% of the vote. So a lot of people feel that if you're gonna do the first reform, you have to combine it with the second. Now, one thing I'll note, because we've been talking, part of our discussion has been why was it unsuccessful? And maybe it was unsuccessful in part because Idaho voters weren't as familiar with the proposal and they wanted to know more about it, or they had some doubts or skepticism about it that needs to be addressed. One thing that I think is important to note is that this reform is being tried in some other states right now. So Alaska adopted it a few years ago. And right now, Nevada is in the process of considering a version of it. It would actually be top five instead of top four. But, a few election cycles from now, Idaho voters might be able to look at some sister states and see how this has worked in sister states. And then they might be able to say, Alaska's been doing it for a decade, and here's exactly how it's worked in Alaska. And that might help to answer some questions people have about it, especially if multiple other states adopt it and then have success with it. So that's, I think, an important thing to keep in mind, is that this is a new reform. Other states are adopting it, and we might learn more information about it. And so, which might help address some of the questions, concerns, doubts, skepticism that people have, so that you could have a kind of voter education effort that is more successful over time.
Do you think this is like part of the initiative process in general is seeing what other states are doing and kind of this laboratories of democracy, especially when things aren't happening on the federal level?
Yeah, absolutely. Um, and I think that, um, yeah, I think this is a really good example of the states acting as laboratories of democracy and trying trying things that haven't been tried before. Can the open primary initiative be put on the ballot again in 2026? Yes. Would the whole process have to start from the beginning? Yes. Um, but, you know, yes, you have to start from the beginning, but we've learned from experience, you have some infrastructure. Um, we've already litigated the question of what's the accurate way to describe the ballots, right? And so that part might go faster. Um, but but in general, yes, you can. If an initiative is unsuccessful, you can propose the same or similar initiative again in the future, but the process restarts.
We only have about a minute left, so I think we'll end there. And I really appreciate you taking so much time to answer all of these questions and present today. So with that, I think we'll end today's speaker series session. And again, thank you, Benji, for taking time out of your schedule. This was really helpful.
Sure. Thanks so much for having me. And I'll just say, I know that there might be some people watching a recording of this later who weren't here in real time to ask questions. All my contact info is easy to find on the law school website. Just search for Benjamin Cover and you'll get my faculty profile with my email and everything. And feel free to reach out to me if you have any questions.
Excellent. Thanks again, Benji.
Yeah, and thanks for inviting me, and thanks to the League of Women Voters for all the important work that you do.